Hey guys, Simon here from the Contract Company. Contracts, that's all we do, all day, every day, and sometimes overnight. Lucky us. Today I want to talk to you about the battle of the forms, i.e. whose contract do you use, ours or theirs? Now just before I go on, if you have any questions about today's video or in general, please feel free to get in touch with us, 1-800-355-455 or simon@contractcompany.com.au. and we'll get back to you as soon as possible. Okay, so you've been asked to sign a contract, or you want to engage someone to provide services to you. Whose contract do you use, yours or theirs? Now, we had this inquiry this morning from a client who basically said he wants to get an app developed overseas. He wants to give the app developer his contract. And I was able to say to him, look, in my experience, we've seen a lot of contracts. In my experience, it's normal that the service provider, i.e. the one who's providing the goods or the services, is the one whose terms are used. Now that doesn't mean it's a have to, i.e. you don't always have to do that. With commercial law you can basically end up doing whatever you like, but it's normal that the person providing the goods or services offers to do so on their terms, and then you usually then would look to, negotiate or amend those terms. You can, of course, always put forward your own contract if you're the recipient of the services. I think, though, just from what I've seen, the optics are better, as in you'll get the deal done and closed sooner if you use the service provider's terms and conditions. So that's the rule of thumb I generally use, which is if you're the service provider of the goods, then you do so on your own terms, which makes sense, I suppose, from a business perspective, i.e. you're trying to sell your goods or services, and fair enough, you should be able to set the terms upon which you want to do that. So then the purchaser of those services or goods should really accept the terms upon which you want to sell. In saying that, though, sophisticated buyers of services will say things like, send me your proposal or your quote, and once I get your quote, I'll look at it, and just bear in mind that me or my lawyer may want to come back to you with changes to the contract. So, what's the point of all of this? A couple of points. One, if you're the service provider or the provider of goods, it's normal that you do so, i.e. you provide your goods or services on those terms. And two, if you're the purchaser or buying the goods or services, then it's normal that you sign up to the other party's T's and C's. But that doesn't mean you have to just sign up to them as is, right? You can, and you should, negotiate those terms. So for my bloke who was looking to get an app developed, I said to him, look, if you want to sign up to and use the app developer's terms and conditions, that's fine. You've got a couple of key issues. Are you getting what you want from the app, in terms of are you getting what you pay for? And secondly, and probably more importantly, it's the IP issue. Who owns the IP in the app? And when is that IP transferred? So as long as he made it clear in the contract that he will own the IP as and when it's created, he's laughing. Okay, so I hope you found that helpful. If you have any questions about today's video, please give us a call, 1-800-355-455, or get in touch with us here at the Contract Company, simon@contractcompany.com.au. Thanks very much.